Sure.
Do you think reform is going to come through the judiciary or through the legislative?
I think it's going to have to be both. This is what I talked about on Freedom Watch with Judge Napolitano, and what I wrote about in the Bergen Record last summer. This really is the floodgate. I mean, this really opens the floodgates. You can't, in my view, you cannot have a regulatory scheme that works the way it does here in New Jersey, consistent with this. You really can't, because it's, New Jersey law is kind of backwards. It's on its head. New Jersey law bans entire categories of firearms and then gives you exceptions. And imagine if you were, the First Amendment worked that way. All books are banned, but you can have books in your home. You can have books in the library, but you can't transport books from your home to the library. And if you go and have a slice of pizza, you go to jail.
That's how ridiculous.
It's crazy, but that's how we do. That's how the New Jersey treats the Second Amendment. So, my view at the time, and I still think this is true, is that what's going to have to happen. It's going to be a combination. What's going to have to happen is the legislature is going to have to undertake some significant reforms, or the courts are going to do it for them because they're not going to have a choice, I think.
I guess my question is, do you think we're going to have to pursue a case all the way up to the Supreme Court before the legislators will act?
It's hard to say. I mean, I know what one thing we know is, for example, Steve Sweeney, the Senate President, is actually fairly friendly, as I understand it. So the legislative situation in New Jersey isn't nearly as bad as it used to be. So I guess it's going to, like I said, a little of both. I think we'll probably see some legislative change. I don't think it's all going to be through legislative change. There's going to be some fights. I think the Mueller case, I think Kerry is going to be. I think that's going to have to be done judicially. I just don't see the legislature in New Jersey, doing the right thing there. Who knows? Things change, but I think that's going to be a fight.
The Heller and McDonald cases were both decided by. I mean, we won, but not by much.
Right.
Okay. What are the possibilities, or what do you see might happen in the future where a case that addresses similar issues may come before the Supreme Court and be reversed? In effect, the Supreme Court would reverse itself, and by a 5-4 decision would say the Second Amendment does not apply to individuals.
Well, to get something that radical, you'd need a change in composition of the court, because I mean the five justices that were in the Heller and McDonald majorities, I mean I think they're pretty clearly on that page with the individual right to keep and bear arms. Someone retires and someone unfavorable is appointed. Well, you know what? That's a pretty fragile 5-4 majority. Suddenly you're 4-5. But I think the bigger danger, honestly, is as these cases push forward, you have to pick the right cases, because a bad set of facts can get you a bad decision, and bad decisions create bad precedent. And judges do pay attention to what other judges do. So what you don't want to do is you don't really want cases where you have drug dealers coming before the court talking about their right to keep and bear arms, or rapists or murderers coming before the court to talk about their right to keep and bear arms, because you know what? Nobody's sympathetic to them, and no judge is going to go out on a limb and push the envelope of the Second Amendment. I mean, if you're asking a judge to take the current law and just push it a little bit here, which is how it works, they're not going to do that for a drug dealer. They're not going to do that for a rapist. So it's very important you get the right cases. Now, unfortunately, unlike the First Amendment, unlike other situations where you can carefully pick your plaintiffs, if you've got a criminal defendant that has a gun charge, their lawyer kind of has to make a Second Amendment argument. I mean, he's obligated to defend his client as best as he can. So there are going to be a lot of cases out there where you have these criminal defendants just making all sorts of Second Amendment arguments all over the place, because they've been arrested on gun charges. They may be obviously guilty. They may be the worst people in the world doing the most violent things, but their lawyer is kind of obligated to make those arguments. And so sometimes we're going to see more bad decisions in this circle than you might otherwise see in another constitutional context. I don't know if that answers your question. Is that
sort of, but I'm not sure if I had the question phrased adequately anyway.
So what ends up
more things.
Yeah, I mean, what ends up happening, is that you got to make sure that you get that you still have that 5-4 majority for the next case. See, I mean, you've got it's hard to tell. I mean, everybody always thinks, oh, Anthony Kennedy, he's the swing vote. Well, he's not always the swing vote. Sometimes he is, sometimes he's not. And it's not even clear that he's a swing vote here. We don't actually know who voted for what reason. You know, there's something interesting in the Heller case. I don't know if you've read it or you've heard about, you know, some of the language in there. There's a part of the Heller case that's Scalia, Justice Scalia wrote the decision, and he put some language in there that's a lot of people don't understand why it's in there, or question why it's in there, and he talks about presumptively valid laws. He says nothing in this decision should be interpreted to cast doubt on, you know, presumptively valid restrictions like, you know, possession in sensitive places or possession by felons, things like that. He lists off 3 or 4 laws which, you know, would be presumptively valid under the Second Amendment. And the question is, well, why would he do that? Judges don't normally do that. You don't normally go out, you stick to the facts of the case. And you make a decision based on the facts of the case. You don't say, oh, and by the way, this law is also valid, and this law is also valid, and this law is also valid. That's very unusual. And the question that a lot of people asked when the Heller decision came out is, why did he do that? And one of the thoughts that people speculate is, you know, he may have written that in there to get the 5th vote. One of the justices in the majority may have said, look, I'm not going to vote with you unless you put some language in there that I need. It's possible. And who is that? Well, you don't know. Maybe it's Kennedy, maybe it's not. It's hard to know. I will say, I found it very interesting. I attended the arguments in Heller and in McDonald. And, you know, Kennedy was one of these question marks. People didn't really know how he felt. I mean, the only 2 votes you knew you really had were Scalia and Thomas, because they've talked about that kind of stuff in the past. But I was actually amazed to listen to Kennedy on the bench when he was asking questions. He seemed very offended, for example. There was a question about, I'm trying to remember what it was. There was some discussion about, well, people on the frontier defending themselves against Indian attacks. And I think it was the Walter Dellinger who was representing the District of Columbia. Kennedy asked him, do you mean to tell me that a family out on the frontier defending themselves against, subject to Indian attacks, doesn't have a right to have firearms in their home for their protection? I mean, he seemed really offended by that, which was a little bit of a surprise because you didn't know where he stood. And that, to me, that's a visceral self-defense kind of reaction. That's a guy who thinks to himself, how could you possibly suggest that people don't have a right to defend themselves with firearms? I was stunned at that. It was a very exciting thing to hear because you think to yourself, well, we got his vote, you know. So you don't know who the people that you might lose in the next case are. You can't predict that. It's impossible to predict, and that's where some of the risk is, I suppose.
And that also why public opinion is so important. I mean, if you look at the polls today, from what I've read, even with the shootings and the horrible press about what happened out in Tucson, the majority of the people polled believe what the McDonald case held.
Right.
Back in the 60s, the majority of the public probably didn't believe that.
That's right. And
the court is influenced by public opinion. And that's where you're saying the organizations are so important, and everybody getting involved, and not being embarrassed to stand up around people who think you're not because you believe in the right to bear arms in the state of New Jersey. That's
exactly right. I mean, judges are human beings. You know, I mean, they have their own viewpoints, obviously, but they're also affected by how they're going to look when they make a ruling. I'm in front of judges all the time, and you know, judges want to sound sensible. They don't want to do crazy things. They don't want to be the guy in the, the guy in the newspaper that lets some guy go who then went out and shot someone else. I mean, they want to be. They want people to perceive them as rational and sensible people. So you're absolutely right. I mean, public opinion can affect this type of thing.
Yeah, I'm concerned that the gun control rights people are convinced now that the front door is not the right way to go about this. I'm convinced that they're going to try a side door now with regulation of firearms. You know, for instance, we're seeing multitude regulations of the types of firearms, or high-capacity magazines, you know, and basically regulate us down to single-shot rifles or shotguns. There's federal laws for importation that, you know, specify, the BATF can decide whether or not a firearm is sporting or not. You know, and to me, that's just, now they decided that, okay, well, we can't go after the right to keep and bear arms, but let's go after what they can keep and bear. Do you see, yeah, basically regulate us down while not getting in the way of because everyone understands there's a line drawn. You know, we can't have people going around RPGs and rocket launchers and things like that. So both sides kind of understand there's a line somewhere of what types of weapons and what types of firearms. You know, I'm convinced that they're going to, you know, basically go after and say, hey, we're not impeding your right to keep and bear arms. By the way, you can only have 5 bullets in your house, and you can only have a single shot. You know. Yeah, plastic only, you know, so
Right.
I see that's what they call it common sense regulation, and common sense in their terms is absolutely not common sense in what we think.
Well, it's a very good question and comment. Two things I guess I'll say to that. Thing number one is that it's really important to distinguish between the rhetoric in the news and you know, in speeches and how the law works. Folks like Brady Center and Brian Miller and guys like that, they like to say a lot of things. They like to say, well, we just believe in common sense regulation, or we believe in reasonable regulation, but those are not legal standards. You can't, in fact, it's kind of interesting. One of the things that Heller did was the Heller decision is, if you put all the opinions together, because the majority opinion was 64 pages. Justice Stevens wrote, I think, a 90-page dissent. Justice Breyer wrote a huge dissent. They're just writing and writing and writing. By the way, I will tell you, I don't know, this may not interest you, but between the Scalia opinion and the Stevens dissent, this is some of the most interesting historical writing on constitutional law you'll ever see. The Heller decision, I'd recommend that you go at least read some of it. It is fascinating. You never see this. You don't often see this in judicial decisions, even Supreme Court decisions. Not only did the majority decision opinion, but the main dissenting opinion went back in history, back to the framing, back to the adoption of the Constitution and the Bill of Rights, and just went relentlessly through the history, the resources, both of them. Stevens happened to have been completely wrong, but it is an interesting exercise in scholarship that these guys did, they laid out, and the Heller opinion lays out something very interesting. They lay out the basis for the decision, the fundamental right. There's actually something hidden in there that probably a lot of people don't realize. There's really kind of a right to self-defense in there too, in Heller, which underlay the whole thing. So you have to, when you're going to look at these reasonable regulations or common sense, laws, ultimately judges have to go back to the fundamental basis for how the decision was made and what the reason for the right to keep and bear arms was, why we have it, why it's worth protecting in a court, and why the Constitution protects it. So if you go back and you say, well, it's all about self-defense, it's all about personal protection and protection of your family and your home or wherever, then you look at these like reasonable regulations or this common sense gun control and you say, well, is that consistent with why we have a right to keep and bear arms and why the courts find it worthy of protection? And that's how these things have to be attacked. And that's where you get this incremental approach. You ask the next question and then the next question. If we win the carry cases, well, then we know that we have a right to defend ourselves on the street. Now, how can we carry? Where can we carry? Those are all unanswered questions. How many, what size of a magazine can we have? What size of a magazine does the Constitution protect? All unanswered questions. You're right. They've lost the main battle, but there's all sorts of other battles that they're going to fight. Little small battles here and there. And as the envelope gets pushed farther and farther and farther, and as the scope of the right gets larger and larger and larger, hopefully, as we're successful, those battles get pushed away, hopefully. And that's the idea, that's the concept of how this has to work. So as they keep coming at you with more stuff, you keep pushing it outwards, and the scope of the right gets larger and larger until it sort of reaches its limit. Theoretically, I guess you can imagine, at some point it's going to end, and at some point judges are going to say, that's it. You've reached the outer limits, it's this, and it's not outside that. That's how the law works, and that's the essence of what I've been describing, and why this is so interesting. Because the Second Amendment jurisprudence has just started. It's go on for decades and decades and decades, and we're all going to see it, or we'll see some part of it. And my children, my daughter will see it when I'm gone, hopefully, and hopefully it keeps going.